You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have doctor. I have went to the hospital and everything. I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So the whole senior year, I got a 5-year-old in kindergarten. And my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm like, oh, I miss my daughter's graduation. She spoke. It was my graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. So we told for my kids. That's what a chance to do for me. You know, Mom, thank you.
Unless I may ask, I've been school, Joe. Yeah. And you stated that earlier. Miss Evelyn Thibodeau, I believe that is her grandmother, correct?
Yeah, exactly.
Hold on, ma'am.
At some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she not to have contact with Miss Thibodeau? Will Miss Thibodeau say yes? Thank you.
Any questions about that? About the count? That's count 8 with the contact. Okay. Then at this time, based on the testimony, I am going to find counts 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yeah.
Any additions or corrections to that report?
No.
Nothing from the state, Your Honor, unless the school has something to add.
Do you have anything to add that's not already in your report?
Yeah.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself.
Okay. All right. Argument, Mr. Lewis.
Well, Judge, I can definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that type inmate tomorrow may have, or any programs that probation deemed appropriate for her. I have had conversations with her and many meaningful conversations with her where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity. It didn't go well, but I don't think the mental health issue were addressed, mainly just substance abuse at that point. I think if we can get a handle on that or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation. And be able to lead this.
I mean, it's hard when
Hold on.
more not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular Safe P or special? Hold on.
Special.
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one. How many?
Yeah, but it's not for medicine. It's for a psycho. I'm not a psycho. I don't have those problems. I mean, something to do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spinal.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for...
It's a psychopath. Nobody's saying you're a psychopath. But you have...
It's called PASS program. I'm not a psychopath.
That's not what it's called. And that's not the reason it's called that. Okay. If you had gone to your appointment and talked to them, then you would know what that was for. And you would know that it was meant to help you so that you could get on medication stabilize and not have the issues that you've been having. I'm going to find that you previously entered your I'm sorry, Miss Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she is clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just run around circles.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and has been just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as
I have one thing to say.
okay?
She's not giving me the information needed to follow up with those type of things.
Okay, well, I don't believe you. I don't believe you.
You know,
Ms. Cole would never say go do something and not tell you where to go or help you get there.
no, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that.
I'm gonna die because I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling, like, she thought, like, I could not get up there.
I'm going to hand you the trial court certification that shows this
I would like to speak to a detective.
This was not an agreement, and so you waived your right to appeal.
I
need you to sign that
I
with
gave
her.
her hospital papers. I gave her everything.
I'm also
I have
handing
a
you.
doctor's appointment and everything. That's what
I've got 5 more years that I could add on to that.
Yeah.
I can give you up to 10.
Madam,
You need to stop talking so I can finish what I need to do. Okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered
I
against.
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you don't.
I'm the wrong person. I'm Devin Atkins. I don't have a gun.
I'm required to read that to everyone.
I don't know what you're talking about. I don't have a gun.
Good. Then you don't have to worry about that. Go back with the bailiff.
Thank you.
Well,
Good morning. Are you Melissa Taylor? What do you have on your...
Oh, this is my son, Brandon Taylor.
Why'd you wear that this morning?
Because he's my entire world.
Okay. Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted the full definition of use. I have the print out paperwork with all the information. They're extremely expensive. I'm not going to get the funds gathered for that.
Who'd you talk to?
I spoke to
Where?
come out to
Where'd you...
back in today.
Okay. Did you talk to some more since that last court date?
The last hearings. You asked you instructed me to get 3 questions.
Mm-hmm.
That was what I did. Can you get that turned in please after all of this?
Okay. If I test you this morning, you can have anything in your system. Have a seat in the jury box. Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case.
Okay.
If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
And I have a skill question, please.
Mm-hmm.
And I about to be sitting.
Yes, you're going into custody right now.
Okay. I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I
Go back with the bailiff right now. Go back with the bailiff.
he
Go with the bailiff. All right. Are you Rebecca Rido?
it's
And Ms. Rido was previously in court, entered pleas of guilty in cause numbers 230928, 232106. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
I don't think so.
And there was no agreement. This was just open to the court. Is that correct?
I believe so. I didn't represent her at the stage where she ended the plea.
Okay.
Understanding it.
They were open. And are there any additions or corrections to the pre-sentence report?
No, she doesn't.
Not from the stage yet.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentences consecutively, which means obviously stacked on top of each other. And I think I could do that in, I think 2106 and 2107, maybe not, but the other ones I can. Are they different dates?
They're all good.
Are they? Hold on, I'm looking. Yeah, they're different dates.
Make sure I've got 4 of them.
They are. All right, so asking me to stack any sentences, and then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit. So, Mr. Kimler, if you would like, you may proceed.
Yeah, I'll just wrote that seems to be an aberrant practice as far as its harshness, its fatal attention to harming this defendant. And I don't know that this stands out from the few other cases before this court to deserve such treatment as what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences to deny discretionary jail credit. I mean, defense certainly has criminal history, but it's not to such an extent or degree in the circumstances of the individual cases aren't such to the extreme degrees as it's more accumulation, and certainly the denial of her jail credit is it's problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. On the grounds the state would be attempting to deny that. I don't know. But of course, we would argue that she should receive credit as every other defendant before this court has for the jail time credit that they've done for some of these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge. And there was notations there as far as the preventive also mental health issues. I believe I believe her to be mentally competent. Now, I of course wasn't her attorney when she entered the plea, but I would assume that she's been incompetent as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. If you would note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and then turned to theft in an attempt to maintain
funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember those. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does in fact indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is having mental health issues as something that mitigates their criminal conduct. But I do think that in this case, it is well documented, going back again to her military history, that she has some mental health issues. I think probation is an option with the court. Obviously, we just think jail, you put her on probation. And I know that the pre-sentence report, if you look at Eric Tibbs, but they indicate, doesn't really indicate that they're, while they're not recommending probation for this Rido, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is.
I mean, well, it is an option, but that's not realistic on what's going to happen today.
They were mentioning that she gets assessed with a specialized mental health caseload.
I understand that.
So just to note that is in the report.
Thank you.
If the court isn't inclined to consider probation for Ms. Rido, then certainly I think that while she's serving whatever sentence the court gives her, she'd have the opportunity to try to reflect on her actions and perhaps reassess those, where she is with this, and as far as addressing her mental health issues when she gets out, that she'll be able to do that and maintain a law-abiding lifestyle. She has maintained employment, I think, 30 years since she was home, if she will. She has maintained gainful employment in the past when her mental health is stabilized, and I would anticipate she would be able to do that in the future. She does have the part of mental health regimen. That would be for probation, obviously, but we're not inclined for that. So we would ask her, and it's certainly that would be concurrent, and that she would be given her jail credit, and that's something along the lines of 12 months.
Thank you.
You want to address the court?
Well, I just want to say that I do apologize to the court, and I apologize to mom. And I be dealing with some things like those help, but I just want to get a chance to go and take care of my kids. I missed graduation, I missed prom, the whole senior year. I got a 5-year-old in kindergarten. And my mama got to take care of. I'm just tired, and I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm like, I miss my daughter's graduation. She spoke. It was my graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. So we told for my kids. I want a chance to do something. Mom, thank you. This is what I think.
Sorry. So, Ms. Rido, I understand that you're asking for a chance at probation, but you've had chances at probation. You've been given these opportunities in the past for any kind of help and treatment and all of those things. And all of those probations were revoked. And you've had 5 felony probations revoked, 2 at one time, 3 at the other time. So I understand that they were kind of clumped together, but still, after those, all for thefts, you're here there was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself. Mr.
Judge,
Coleman, I know what you're...
Yeah, you've essentially hinted the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of the same old song. Just different defendant. I apologize, give me a chance. I've got all the issues. In fact, yeah, so one step further than the same old song. It's the greatest hits. It's what you hear. Time and time. I'm sure she said it back in 2011 when she got probation. In 2014 when she got probation. In 2017, just I apologize, give another chance. Got these issues. Judge, if ever there's a case to consider denying her the discretionary just created under the Code of Criminal Procedure, this is the case.
And it's my understanding with regard to that.
I know it's kind of it's
Problematic.
well, I don't say it's problematic, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes. That's in the nutshell, Judge. And I just say this is a case of that to be considered. And I also say this is the appropriate case to accumulate her for her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks. That's all.
Thank you.
I would just argue from the standpoint of equal protection as far as the other defendants.
Well, so here's speak up so she can hear.
I would argue from the standpoint of equal protection laws, Your Honor, what distinguishes her from the other defendants that have been before this court or similarly situated with similar criminal histories?
Well, here's where
I'm sorry.
here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were. And I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse. And when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to